Welcome to the Baker Law Group Tip of the Week. I am Drew Baker, and I am joined by Mr. Attorney Matthew Dixon. How you doing, Matt?
I'll tell you what, as much as I love the winter, I am not ready for this bitter cold we've had the last few days.
No. And with bitter cold comes
Snow and ice.
Snow and ice. And that is why it is the most slippery time of the year. I was going to sing it. I saved you.
Thank you.
Especially with headphones on.
Thank you for saving us.
Absolutely. Well, today's tip of the week is going to be involving what do you do in the event you are out at a business doing your Christmas shopping, getting the list checked off, checking it once, checking it twice. And in the middle of that, you happen to encounter some snow and ice on a business owner's sidewalk, steps, entrance, exit. However you find it, you step on it and you fall. The question is, a lot of times in slip and fall cases, is who's at fault? So let's start with like the general idea of what is a business owner's duty to the patrons and those that come to visit the store and potentially purchase merchandise.
Yeah, doesn't a business owner typically have a reasonable duty to keep its visitors safe, the guests safe from hazards?
That's correct.
Yeah.
You are right again. It is basically just a reasonable duty to its patrons to maintain a safe environment for them. Of course, there's all kinds of different fact patterns you can run here in terms of what is safe, what's not safe. A lot of times it involves things like spills in the store, clear liquid on the floor. And there's a whole other area of law we'll talk about some other time that involves warnings and what's an adequate warning, what's not. So, but today specifically, we want to focus on what is the business owner's duty, which is a component of negligence, to that individual that's coming to shop at that store when it comes to just the accumulation of snow and ice. So you've got a snowy day. We'll run a few examples here. I walk onto the sidewalk. Nothing's been done to the sidewalk. It's just a nice winter, Christmassy, white Christmas looking day. And there's an inch or so of snow on the sidewalk. I go to step onto the steps and I slip on the snow itself. So what do you think is going to happen in that case? And then we're going to talk about what the Supremes at the Supreme Court have to say about that.
Wow. Well, it seems like, somebody should have done something to shovel it. I mean, gosh, just a lot of snow out there, don't you think?
Well, prior to reading this opinion, I would have maybe thought that, although I did better in law school than you did, so I didn't think it. But regardless, let me just tell you what the Supreme said, and that way you'll know the next time.
Oh, well, I appreciate that.
No problem. What they say is, generally speaking, if you have a condition that is a, quote, natural condition, that we have a duty as patrons, not the owner here, but as patrons, to exercise open and obvious, reasonable care. The concept that we all know ice and snow can be dangerous, can cause you to fall. A lot of variables as to maybe why. But regardless, we know that when it's snowing outside, it's going to be more dangerous and more risky to walk around than it would be, say, on dry pavement. Ordinarily, an owner or occupier has no duty with regard to the dangers associated with natural accumulations of ice and snow. And again, the rationale, same with what we were talking about before, is everyone is assumed to appreciate the risk involved with natural accumulations of ice and snow, and therefore everyone is responsible to protect himself or herself against inherent risk presented by natural accumulations of ice and snow. I love how the Supreme Court always just compiles as many big words as possible into one sentence.
It jams it all in there.
Jams it in there.
Says good luck.
And says, figure out every word. But all they're really saying is, if it's left alone, you should know better. If it's left alone, be careful. Maybe don't wear the most slippery shoes you have in the house when you go out shopping. It's kind of what I think they're getting out there.
Yeah.
But what happens when something isn't left alone and either maybe they've done something that's changed the condition, maybe with, of course, the intent to make it safer, or there's some other, we'll just call it unnatural accumulation of ice and snow. What happens then?
Well, so I guess we're talking about, a situation where the business owner has the snow removed, let's call it from the parking lot, let's call it from the sidewalk, whatever it is, has it plowed or shoveled, but maybe doesn't put, de-icer or salt down.
Ooh,
so there's a sheen,
dangerous.
there's a sheen of ice now that you're not looking for because you think it's been properly shoveled or plowed.
Yeah, come on, man. You got to put salt down on the top of that ice, or you're going to have moisture that then, if it's super cold outside, it'll just freeze over.
That's right.
And now we've got an ice skating rink.
Yep.
Not good. Not good. Or it could be a situation where maybe the plows plowed the snow in such a way you have to go a certain way that's more slippery. That's another possibility. Maybe they've, positioned the snow in the lot so that you're forced to go through the ice skating rink to get to the front door.
Right.
That's another idea of maybe. So what does the court say about that one? The court says another exception is when it is shown that the owner or occupier was actively negligent in permitting or creating an unnatural accumulation of snow and ice. I like this one. You'd give an example when we were talking about it before our tip of the week. Coffee.
Oh, yeah. What if you threw a pot of coffee out the door, or, a pitcher of water, whatever it is, and it gets out, gets in the cold weather, freezes over.
Right.
And there's nothing else on the ground. There's no snowfall, no anything, no precipitation. That's unnatural. That's man-made.
Yep.
And nobody's looking for that. Nobody's presuming there's going to be frozen over pot of coffee.
Yeah, because you go to that pot of coffee that's been there for, maybe 6 hours, and you want to make a fresh pot, so you just kind of toss it out the front door, and then it creates ice on the steps. Now that's a situation where that would not fall within those protections for the business owner of a natural condition that's unencumbered by some other act by them. And then the other exception is getting back to kind of the snowplow situation, or maybe where they don't put the salt down. It's when an owner or occupier is shown to have notice, actual or implied, that a natural accumulation of snow and ice on the premises created a condition substantially more dangerous than what the business invitee should have reasonably anticipated. Again, here we go, long sentence. In light of general prevailing weather conditions. I think in this instance, you got to kind of unpack that sentence again. But what they're saying is, if I fall on the ice, I don't hurt myself, but then I go in and I give the business owner notice, and I tell them, hey, your steps are really slippery out there. I fell coming in. It seems to me that those should be cleared off. Now the business owner's duty is heightened because of that notice. They're aware there's a dangerous condition. This might be an example where the owner has a gutter that's got a hole in it, and there's some water that's going through the gutter, hasn't frozen yet. It drips down onto the steps. And then a person comes in and says, hey, you've got a gutter out there that's leaking, and it's creating a huge pool of water, and it's freezing over. I almost fell on it. I think at that point, now you may have an action against the business owner if they don't take care of the issue.
Sure. Yeah. They have actual notice then.
Right.
What I always like, I look at this and I say, they're looking at you and me and saying, you should have reasonably known it's wintertime, this stuff freezes over, and it's slippery. What if you're from the Caribbean?
Yeah. What if you're reasonable? Your level of reasonableness is not based on any foundation.
Right. You don't have any real experience with ice or snow. You come to Columbus, you go shopping. It's whatever. You're out and it snowed, and they've, whatever. You have no reasonable anticipation of how slippery snow may be, because maybe you've never seen it before. So maybe in that circumstance, you fall outside of the rule.
That could be. And I think as a business owner, the things you want to be aware of, number one, I know in our cases, we always look to notice as being one of the main things to strengthen the case. So if the individual running the business knew about or should have known about a particular dangerous hazard, whether that be snow and ice or any other, hazardous condition on the premises, not telling someone about it with a warning or not remedying the situation is a great way to get sued.
Yeah.
If you do hire a snow removal company, which a lot of people do, just make sure they're doing their job. And I understand that at the end of the day, you may be suing the snow removal company for what they didn't do, but that doesn't change the fact you're getting drugged through the lawsuit. As a business owner. You're going to be named as a party. You may do what's called a third party action against whatever subcontractor you hired, but that doesn't save you the attorney's fees, the time, the hassle associated with the lawsuit. You're still going to be in it probably till the end, or at least a good portion of it. So that is another issue that you might want to think about. If you're going to hire somebody, maybe send somebody out to make sure they actually did it or they did a good job. Didn't forget to put the salt down.
Well, one of the big takeaways is for anybody who, does unfortunately happen to slip and fall on some kind of accumulation of snow, ice, whatever it may be. You want to make sure that you take some pictures of everything around you.
Absolutely.
You
Yeah.
never know if you're going to have a claim or cause of action against a business owner, but you want to get pictures, you want to get a report done, you want to make sure everything's handled in that respect, because chances are the next day those conditions are going to change and you'll no longer have.
Oh yeah, and the report is really important. A lot of people, whether it be because of embarrassment of the fall, or they just want to get home, because normally when we don't feel good, we want to go home.
Yeah.
It's worth taking the 20 minutes, 30 minutes to make sure the business fills out an incident report about the fall, because that does become very important in the event you have a case down the road. Without any actual recorded incident report, sometimes you run up against that their word versus your word. It could be that they don't have any cameras. They might have cameras, but nonetheless, it's going to put them on notice and put their insurance company on notice. An incident has been recorded, whether that be on paper or on video, right. But at least it solidifies the fact that it happened. The insurance company is on notice for it. And then the process begins versus coming in after the fact and trying to say, well, this happened to me, and getting a lot of pushback from the insurance company saying, we don't have a record of that. We were unaware of it. So yeah, those are all things to take away from this week's Baker Law Group Tip of the Week. Next week, we're going to cover what do we do if we are having guests over for that big Christmas feast. Ham, turkey, all the fixins.
All the trimmings.
Yep. And if you come over to my house and you're a guest, what do I owe you in a duty in terms of keeping my premises safe, my house area, internal, external, but more importantly, on the outside? What duty do I have as a homeowner to my guest when it's snowing outside and it's the most slippery time of the year?
I'm excited to see the result of that research.
Me too.
Yeah.
Me too.
Let's see what we get.
All right. Well, until next time, this has been the Baker Law Group Tip of the Week.